sound record. I'm going to start again. Thank you for joining us this evening. I'm Jennifer Dye, a librarian at Detroit Public Library. We have had a strong program with the League of Women Voters Detroit for about 2 years now. We present on issues of concern to Michigan voters about 10 months of the year, and our issues address other people as well as Michigan voters. You were brought into this program muted. Please put any questions into the chat. Ruth Coolwine will capture these questions and ask them at the end of the presentation. We are sometimes able to allow people to unmute at the end to ask questions directly. This presentation will be recorded and will be made available on DPL's and the Detroit League's websites. Deborah Bunkley will speak briefly about the League and the Detroit group. Deborah?
Can you hear me?
I can hear you now, yes.
You're on your mute.
Okay, now can you hear me?
Now we can hear you.
Okay, I'm currently the acting president for the Detroit League. And the first thing I'll start out with is democracy is not a spectative sport. The Detroit League, we are a nonprofit, nonpartisan political organization made up of both men and women from Detroit, Hamtramck, and Highland Park. We endorse neither candidates nor political parties, but strive to make members of our community better informed at the ballot box. We do this by encouraging reasoned and active participation in local, state, and national politics. Now, the mission of the League of Women Voters of Detroit is to encourage our communities by registering new voters and providing educational opportunities regarding governance, decision-making, and public policy. And right now, we have a lot of things going. We just had our membership meeting. We had a state representative, Helena Scott, speak. So we have different speakers come in we try to have different speakers come in for our meetings. And we encourage the community to be actively participants in democracy. So with that being said, we are always recruiting, trying to get new members for the Detroit League. And we are always registering people to vote. We're currently going back into the high schools due to COVID. We were out of the high schools, but we're doing that. And we're still doing active voter participation engagements. So with that being said, you can look us up on lwvdetroit.org and become a member at any point. Thank you. And I will leave it there.
Thank you, Deborah. Our speaker tonight is Professor Ellen Katz, who is the Ralph W. Aigler Professor of Law at the University of Michigan Law School. She will give us a history of the Voting Rights Act and address the ways in which judicial decisions, especially from the Supreme Court, have limited the statute's impact. Ellen?
Terrific. Well, thank you. And thank you for having me tonight in this virtual forum. And I will thank Ruth in advance for helping me. I couldn't get the slides to share, so she is going to pull them up and we'll go through them a little bit. I'm happy for this to be an informal discussion, and so I will rely on our moderators if they want to bring in questions at any point. The topic is the Voting Rights Act in its current state, but to talk about that, I thought it makes sense to actually start long before the Voting Rights Act was enacted. And so the first slide is a sketch from Harper's Magazine from 1866, which shows the first group of voters, Black men voting after the Civil War, pursuant to the Reconstruction Acts that were put in place in former Confederate states. Part of the condition for re-entry into the Union for the Confederate States was to adopt new constitutions that eliminated race-based barriers to political participation. in part, it was a recognition of the service that many Black men had provided for to the Union during the war, and it was also a political judgment on the part of Republicans in Congress at the time, knowing these Southern states were coming back and wanting to ensure more representative representation to keep them in power. Constitutional amendments followed. The 14th Amendment imposed penalties for states that would disenfranchise men who otherwise possessed qualifications to vote on the basis of race. So it threatened, at least it was never enforced, but threatened to reduce congressional representation, the number of seats a state would have if they engaged in race-based discrimination. And the 15th Amendment, of course, followed quickly thereon, in that prohibited denials of the right to vote on the basis of race explicitly. Black voting in the South in particular met resistance from the beginning, and that resistance was violent and involved fraud throughout, but for the first years, those were the primary tactics. Beginning in 1890, every Southern state held a constitutional convention, every former Confederate state, in which they adopted I guess we'll use the word lawful mechanisms for disenfranchisement. And so, Ruth, if you would go to the next slide. So this is John Knox, who was head of the Constitutional Convention in Alabama that met in 1902 and adopted a series of restrictions on the right to vote. They assembled, as did each of these conventions, with the express purpose of entrenching white supremacy. We know that because they stood up and said, we are here to entrench white supremacy. And they adopted a bunch of familiar tactics that the Voting Rights Act decades later is going to attempt to tackle. And so these are just these slides are maybe just the next slide, Ruth, and we'll so this is the Constitution that's adopted in Alabama. Corresponding ones are adopted, as I said, in every Southern state, 1890 through the early part of the 20th century. And they have in them a whole slew of restrictions. And so it would be helpful if I'm in the next slide too. Sorry, this is just going to be a few in a row. So this is a poll tax receipt. One of the things that were put in place was a poll tax, that you had to pay this tax. It actually wasn't to vote. It was a tax that was levied on all residents, but the receipt from the poll tax was a necessary prerequisite to vote. And where they were implemented, it was put in place, widely used, and that you could, there was no penalty for failure to pay the poll tax, but for a denial of the right to vote. They were cumulative, so if you hadn't voted in the last few years, you would have to pay for all of the poll taxes that you owed for 5, 10, or however many years you hadn't voted, and it had a predictable effect on participation. So we go to the next slide. Okay, so this is a copy of Louisiana's literacy test. You can look at some of the questions that were put in place. Another device that was used was the literacy test. They come in different formulations. These questions, my students always spend some time with them. They're not, so as you can see, it's a frivolous test. It's meant to trick people. They were not administered in a fair way. So-called educated suffrage was something that was promoted, but these tests were never administered in that way. And many of the questions that you can see on this page, if you go to the next slide, is the second page of this, are not serious. Number 20, spell backwards forwards. I still don't know what that one means. And many other questions. They were meant to disenfranchise people on the basis of race, and that's how they were employed. The next slide is from North Carolina, and here you see an example of another tactic, which is the grandfather clause, and it's one of the few that was actually outlawed in advance of the Voting Rights Act. And if you read this through, it entitles a person to vote if they are eligible to vote on, if they were eligible to vote on in January of 1867, or are the lineal descendant of somebody who was eligible to vote on those days. It's called the grandfather clause. If your grandfather could vote, you could vote. The date is significant. The date is before Southern electorates were expanded to eliminate race-based restrictions. This provision, the grandfather clause, was struck down by the Supreme Court in the early 20th century in a case called Gwynn. In so doing, the court basically says, no, that's too obvious a violation of the 15th Amendment. But in striking that down, the court does, this is in Oklahoma's grandfather clause, the court upheld the other sorts of restrictions that I had mentioned. So there's, let's go to the next slide. I'm going to fast forward. Needless to say, a lot happens between the earliest 20th century, but I'm going to do one more case before we get to the Voting Rights Act itself. And this is from Tuskegee, Alabama. It's a map of Tuskegee that comes out of the Supreme Court decision that involved this case. And you see in the upper left corner of the slide, the Tuskegee Institute is there. And if you can see the color, the line, the sort of lighter white section, literally, is the new borders of the city of Tuskegee. And so what had happened in the late 1950s, there was a school board election, and an administrator at the Tuskegee Institute had run for office, and she didn't win the election, but she did better than a bunch of white voters in Alabama at the time thought she should have done. And so the Alabama legislature adopted a new law that redrew the boundaries of Tuskegee. And the sort of strange shaped figure that you see in this slide is the result. It's a 28-sided figure, and its result was to remove, and there's different reports on precisely every single Black voter from the city, or close to every single Black voter from the city. And so there's no legislative history, there's no statement as to why Alabama passed this, but we know from the odd shape, the history surrounding it, why the city boundaries are redrawn the way they are. Charles Gomillion, who is in the next slide, brings suit. He's a sociology professor at Tuskegee at the time, challenging this, saying it was unconstitutional for Alabama to do this. And what made the case a difficult one, it seems from a contemporary vantage point, well, of course, that must be unconstitutional, was it was a challenge to the lines, the boundaries of the city. And at that time, the Supreme Court had been quite clear that it was not going to read the Constitution to allow or to authorize a redrawing of electoral district lines. And this had come up previously in the context of malapportionment, where congressional districts, where state Senate and House districts had not been reapportioned for decades. And as a result, the population had shifted. Many had many more people, some districts had many more people than other districts. And the Supreme Court, about 15 years before this case came up, the Gomillion case, said, we can't help you with that. That's a political question. Go to the legislature, ask Congress to fix it, ask the states to fix it. We're not going to help. And so Alabama thought when it redrew the lines to Tuskegee that it was going to be clear of a constitutional challenge because the Supreme Court doesn't mess with lines. But the Supreme Court in a decision in Gomillion versus Lightfoot says, well, we know we said that, but these lines under these circumstances, denying Black voters there, and the language is pre-existing right to vote, violates the 15th Amendment. And if you see the next slide, I have justice slides. Here's Felix Frankfurter, who wrote that opinion. And it was noteworthy that he wrote the opinion in part because he was the one who had written the earlier decision that says we don't mess with district lines. We don't mess with district lines, but here we're going to mess with them. And we're going to say that Alabama can't do what it did. What it did here was to deny the right to vote. That I'm about to get to the Voting Rights Act. I'm mindful that I've been talking for a bit now and I haven't yet mentioned the Voting Rights Act. Gomillion opens the door to a series of deeply consequential Supreme Court decisions that are beyond our scope tonight, involving the emergence of the one person, one vote doctrine that caused the redrawing of so many electoral districts nationwide. And in the years that followed, we see a series of important decisions, both recognizing that power under the Constitution, but also in the country, we see legislation emerging, Civil Rights Act, particularly of 1964, but there's a Federal Civil Rights Act of 1957 and 1960 that begin to give the Justice Department more power to deal with voting discrimination. So if you go to the next slide, we'll see we're going to walk into the Voting Rights Act and what's happening. Under those early civil rights statutes, 1964 is the Civil Rights Act that most people are familiar with. It's the one that takes down the whites only signs in places of public accommodation. It bans discrimination on the basis of race and actually sex and other characteristics in employment. But for our purposes, it also gives the Justice Department new powers to pursue voting cases. And the earlier two civil rights acts did as well. But what was happening, or what federal officials were finding, was when they challenged a particular literacy test or a particular device that was being used systematically to screen out Black voters, even though they could litigate those cases and win those cases, little changed on the ground, because after they litigated those cases, what happened next was the jurisdiction just adopted a new provision, and the status quo stayed the same and numbers didn't change. And this chart, which is part of the legislative history behind the Voting Rights Act of 1965, gives you, I think, some very telling numbers from Alabama. So the first column after the name of the county, you see the percent of the population that participated in the presidential election of 1964. And the Voting Rights Act of 1965 is going to take this as an important number. And you see all of these counties have very low participation for a presidential election. And then the columns that follow give you the sense of why. The white population, the white registration numbers in the percentage, and then the non-white corresponding numbers. And if you sort of go down, you can see varying degrees of white registration. The percentage points are all fairly high. There's a few aberrations, notably there's also above 100% registration in certain jurisdictions. And then if you go on my screen, I actually can't see the final column, but I know it's there, and I imagine you can see it. You see the corresponding percentages for non-white registration. And here you see the numbers and the percentages are shocking. Very low numbers. Dallas County is where Selma is. There you can see 335 registered voters out of an eligible population of 15,000. And this is in the early 1960s where we're seeing these numbers. And there's a sense that something needs to be done, and something needs to be done about this. And the next few slides are going to take us to Selma. I know many people are familiar with this. There's a voter registration movement in Selma to do something about those numbers that we see. And the folks who organize this, there are many film adaptations of what happens next in Selma. If you haven't seen the Eyes on the Prize, the PBS series, it's quite dated now, but does the Bridge to Freedom episode I have my students always watch it, is quite effective in describing what happens in Selma over the days that follow these protests. And Ruth, if you can just go through the next few. These are this is John Lewis leading a protest across, this is a very famous event, the Edmund Pettus Bridge, to protest the refusal of election officials in Selma to register Black voters. Congressman Lewis is not a congressman yet. He's 25 years old on the day of this march, and they famously meet the Alabama state troopers on one end of the bridge, and violence erupts that is captured in these are very famous images. It's broadcast on television that evening, and the country sees what's going on. Just let you go through these. And you can stop there, because this is obviously, we're no longer in Selma. Here we have President Johnson responding to the events of Selma Bloody Sunday as it came to be known. And he has addresses a joint session of Congress and calls for the Voting Rights Act of 1965 to be enacted. He famously, in the course of that speech, uses the language of the civil rights movement that we need to overcome. We shall overcome the history of racial discrimination in this country. And again, from a modern perspective, a contemporary perspective, you can look back and be like, well, of course, that would be something the president should have said, but it was a remarkable statement at the time. And what followed was the enactment of the Voting Rights Act. And so the next slide. Okay, so this is not from 1965. This is actually from litigation, the Shelby County litigation, which I'll talk about in a moment that follows, but it provides, I think, a useful way to think about or see what the Voting Rights Act of 1965 did. So it had a bunch of parts, and one of the parts, 4B, is the so-called coverage formula. And what Congress did was it designated jurisdictions that had very low levels of voter registration, meaning less than 50% of the population was registered to vote, or less than 50% of the population, that eligible population, participated in the presidential election of 1964. If either of those two things were the case, and the jurisdiction used a test or device, one of those literacy tests or something like it, the jurisdiction was called covered or became covered by the act, and certain requirements would follow. I will say it's dark purple. I'm not quite sure if that's the color it appears on your screen. The states and jurisdictions that were initially covered by that are the ones that are in dark purple, and it maps on fairly well to the former Confederacy, not perfectly. And if you are a covered jurisdiction, according to the Act in 1965, certain things happen. For 5 years, you may not use your literacy test or any test or device. And here's the big piece of it, or what gave the statute so much effect. If you want to enact any new rule regulating the electoral process, if you want to adopt a voter identification requirement, if you want to draw new district lines, if you want to close a polling place, you have to first get federal permission, either from the Justice Department or from a federal court. And you have to demonstrate that the change with respect to voting is not discriminatory in purpose and effect. So it sort of freezes the status quo and prevents these new discriminatory devices from replacing old ones. It's remarkably effective. And within a few years, we actually see vast increases in Black voter registration in the places and participation in the places where it applied. I said it was enacted in 1965 for only 5 years. Congress extends it in 1970. It extends it again in 1975. It extends it again in 1982. And then in 2006, it does it for another 25 years, although this provision isn't going to survive litigation that follows that. The other colors that you see on the map, with each extension of the statute, the 1970 extension, that formula I mentioned based on participation for the presidential election of 1964 is now going to include the presidential election of 1968. And then a subsequent one is going to include the presidential election of 1972. And additional jurisdictions are brought under the statute pursuant to that. The orangey yellow color jurisdictions, they were covered, and there was a procedure that allowed jurisdictions to come forward and petition to get out of the statute. Basically said, we have a clean record, we've been doing a good job, let us out. And several jurisdictions, as you can see from the map, over the years were able to do this. And the provision was, I mean, there were scores of cases litigating how this provision should be applied. It came to mean that a proposed change could not cause retrogression in the condition of the minority voters, which came to mean don't make things worse. So the jurisdiction had this obligation to show that the proposed change wasn't going to make things worse for minority voters. And it prevented a whole bunch of discriminatory changes. Because the jurisdiction either knew they couldn't get them passed, they weren't willing to try and defend it. And we saw by the mid-1970s in federal court decisions, there's a line that appears that says, Black voters register and participate without hindrance, which is already a remarkable statement about how quickly, one might say not quickly, it's a century after the ratification of the 15th Amendment, and yet how this about it in Q&A, but I won't spend too much time here on it, that restricted Congress's power to enforce the 14th and 15th Amendments. And in the Shelby County decision in 2013, Supreme Court said in essence that coverage formula I mentioned, with using a tester device and having low levels of participation on those particular dates, was no longer constitutional, that Congress hadn't updated it. Congress hadn't addressed the fact that in the court's view, conditions in places where the statute applied no longer warranted or weren't in the same state as they were. Alabama in 2013 didn't look like Alabama in 1964 and 65, and that Congress lacked the power to extend the statute. By striking down the coverage formula, the preclearance or this requirement to get federal approval was eliminated. It's still technically on the books, but it doesn't apply anywhere because there is no coverage formula that would make it applicable. And we saw literally within hours of that decision, jurisdictions adopting new restrictive voting practices, voter identification provisions in particular, ones that had been blocked, Texas among other locations that had been blocked under Section 5 were resurrected and put into place. Let's go to the next slide. Oh, and this gives you this was in the record for the Shelby County litigation. And you do see these are contested numbers, but you begin to see that one of the things that the Voting Rights Act had done, and the court found this to be powerful evidence, was it closed the registration and participation gap, or at least appeared to. Like I said, these numbers are contested because there's a dispute about who's included in the categorization of white, and that they may be there may be greater divisions than this chart suggests. Let's go to the next. Okay, so I'm going to talk about a different provision of the Voting Rights Act right now, and this is Section 2 of the Voting Rights Act. This is not Section 2. This is a picture or a diagram that I will use. I don't know if it's helpful to you. It's helpful for me to think about the problem of racial vote dilution and how it's addressed. So if you look at this picture, imagine the box is a city with very neat boundaries because it is a perfect square, and the red dots is meant to represent a particular minority community. And imagine in our city that there are 4 city councils elected at large, and I mean at large, everybody in the city votes for each city council member, and in this model, the majority outvotes the people in the red dot consistently. That's how a majoritarian system works. By the mid-1970s, and one can say this happened, was recognized long before this, we started to see cases involving the red community or the dot being a racial minority with a distinct socioeconomic status that had experienced a long history of discrimination in voting, where voting is racially polarized, meaning the white section votes one way and the folks in the red dot vote another way. The people who are elected ignore the people in the red dot, or worse, engage in affirmative discrimination directed at them. They can't get their streets paved, their trash collected. They face discrimination in housing, employment, city services, and the like. And there's no real reason for this. Let's go to the next slide. And so one of the things that's recognized is like, well, what if instead of electing our representatives at large, we elect them from districts? And one of the thoughts is, well, here, what do you get? The folks in the red dot become the majority of a majority of a single member district. And this allows for a seat at the table, if you will. A preferred representative can be there to make deals. And let's go just do one more. You could also draw lines like this. And again, these are very abstracted pictures, needless to say. And here the thought is, well, what exactly is the thought here? There's some thought that maybe the minority community can't exert controlling influence, but the folks who get elected will be more receptive to their views, and there'll be more chance for a representation. these different models, ways to think about how to structure an electoral process. And Section 2 of the Voting Rights Act, as it's amended in 1982, the next slide will show Ronald Reagan signing the amendments to the Voting Rights Act in 1982, creates a results-based test for discrimination and says basically that all voters, that minority voters should have the same opportunity to participate and elect representatives of choice. It's meant to target in part these kind of at-large structures or other districting choices that, while it's part of a majoritarian system, make it difficult for minority voters to elect representatives and have influence over the political process. Let's go to the next slide. Back to this one. What happens under Section 2 is there's a lot of litigation. I'm happy to talk more about it. It's intricate. But that under certain circumstances, the Voting Rights Act is deemed, Section 2 is deemed to be violated, where either there's an at-large district or a districting choice that doesn't give the folks in the red dot, and I will just talk about this in the classic example in our history is a Black community within a white majority city. It's not exclusively applied to Black voters, it's applied to Native American voters, applied to Latino voters and others as well. And what happens is under certain circumstances where plaintiffs can bring can make a certain showing of a history, of a lack of responsiveness, of persistent racial bloc voting that prevents the formation of cross-racial coalitions, of non-responsiveness from those who are elected, and so on and so forth, make a claim that the statute's been violated. And one of the things that's happened is that there was a proliferation, particularly in the 1990s, of majority-minority districts that this picture is meant to represent. Changes the face of, literally the face of representation in the United States, from school boards to Congress, and we see minority faces in these bodies often for the first time since Reconstruction, and it changes quite a bit. Let's go to the next slide. This is a representation of a map drawn in North Carolina in the 1990s, purportedly pursuant to the Voting Rights Act. This is a majority-minority district that generated ire on the Supreme Court, because this was not that picture of a clean, compact minority community being put in a district that could be drawn with traditional districting principles. And the court, a separate doctrine, strikes it down, said to draw a district that looks like this, which reflected a complex series of decisions by the state of North Carolina, in particular partisan considerations, ultimately violates the Constitution by considering race too strongly. And there's a series of cases, this is Shaw versus Reno, that continue to this day, a line of cases that say racial gerrymandering cases, race has been considered too much in the process. And we saw a fine line between what the Voting Rights Act requires jurisdictions to do as the doctrine played out, and this competing constitutional doctrine that says you can't draw districts where you think about race too much. Let's go to the next slide. These are just, this and the next slide are just going to be two cartoons giving two different views on the issue of voter ID. And one of the things we see in the 2000s is a proliferation of voter identification measures, getting at fraud, or at least purportedly to address voter fraud. One of the concerns is that it screens out voters who are less likely to have ID for a host of reasons, and the kind of fraud it's purportedly getting at does not exist. Let's go to the next slide. And this is, I've always liked this somewhat silly cartoon because I think it does capture what voter ID laws do and other restrictions. They don't actually totally prevent people from voting by and large, but they make it very complicated and difficult, and more difficult than, to my mind at least, it should be to vote. And they're put up for that reason. Again, editorializing here, that's my take on them, that they don't actually serve, it's not a unique take, that they don't actually serve a meaningful interest, but rather are put in place to make voting more difficult for predictable groups of voters. Section 2 of the Voting Rights Act, which continues to be part of the statute, covers this as well as those dilution claims that I was talking about earlier, just a moment ago. So sometimes they're called vote denial claims, sort of they sound in those first generation issues of literacy tests, poll taxes. It's in that way, things that make it harder to cast a ballot. We saw a bunch of Section 2 cases in the last decade challenging voter ID. They're almost, I think, have they all, most of them lose. Courts have determined that they are not violations of the statute. And we have seen over the last 2 decades in particular, increasingly stringent rules being put into place on how the courts, federal courts and the Supreme Court read Section 2, the restrictions, or how they understand its prescription. I'm going to talk quickly about 2 more cases and then I will stop. So let's go to the next slide. Okay, I don't have a good picture of this one. So this was just from 2021, a case that came up. It's the first time the Supreme Court addressed these so-called vote denial cases, Brnovich versus the DNC. It was not a voter ID case, but voter ID was in the mix. And this case came out of Arizona, involved 2 practices that Arizona adopted. One was out of precinct voting, how it treated people who voted out of precinct, and also some rules about absentee ballots. So the out of precinct rule is you show up to the wrong polling place. What do? You can cast a provisional ballot. If it turns out you are in the wrong polling place, Arizona throws away your ballot. Most other states that have an out of precinct rule will count your ballot for the offices that are on the ballot for which you were eligible to vote. And for most of us, that's typically most of the offices. You can vote for governor anywhere in the state. And typically, you know, and senator, and typically this works for your congressperson, maybe your state senator and state house. And it's a series of local races that you might be in the wrong place and you can't vote for because your city council, you're in the wrong place. And the question is, can Arizona put this rule in place and just toss out the ballot? And the court said, sure. Arizona has an interest in getting people to the right polling place. It was shown in the litigation that this had a disparate impact of voters in Maricopa County, particularly low-income voters of particular racial groups who had less stable addresses and were subject to more moving of polling places from election to election. Court was indifferent to that fact and said that Section 2 of the Voting Rights Act doesn't require Arizona to do anything different than it had done. And again, the second provision was rules for collecting absentee ballots, who can help you mail your absentee ballot. And this had there were restrictions that Arizona put in place. Only relatives, caregivers could do that, and it had an impact in particular Native communities in Arizona, who where folks often lived quite far from a mailbox and didn't have regular mail service. And it seemed that it had been put in place for that reason, or at least there was some evidence of that. And again, the court said this was perfectly permissible for Arizona to use this system. And in the course of doing, the court articulated 5 new considerations that aren't entirely new, all of which make it much more difficult to win a Section 2 case. You could vote in another way, as long as this isn't the only way to vote, as long as the state has an okay reason for why it's doing it, as long as the burden is considered not that serious, and so on and so forth, all of which are kind of pushing in the direction of don't find a violation. The court doesn't quite make it a firm rule, but there's a sense that it's going to be very hard to win in one of these cases. And the last case that I'll talk about in the last 2 slides, we're going to go back to Alabama. And this case is pending in the Supreme Court right now. And we'll see what happens. Alabama drew districts following the census in 2020. This is its congressional districting plan, the different colors of different districts. There's only one Black majority district. That's the light blue, maybe I'd call it teal, district that you see on the left. And a litigation was brought saying Alabama, under Section 2 of the Voting Rights Act, is required to draw 2 Black majority districts, in part because of that history of racial discrimination, persistent racially polarized voting, distinct socioeconomic status, and those factors we talked about, or I talked about a few moments ago. The map on the right shows you where Black voters, Black residents live in Alabama. And if you can see from that and the way these lines are drawn, why, how to put this? You can see where the Black majority district was drawn. And on the western part, the eastern part of the state, there's a line that's going through, that cuts through a sizable Black community. And the district that you see, the majority Black district that you see, reaches into the center and sort of pulls together. The last slide shows you the plaintiff's plan. And the plaintiffs were saying, look, you know, and the yellow maze, call it what you will, there's a second Black majority district that we can draw. Doesn't look stranger, says the plaintiffs, and the districts of Alabama was already drawing. It condenses the Black majority district. And they brought this suit and says Section 2 of the Voting Rights Act requires you to draw this district. And a 3-judge panel that included 2 judges who were fairly conservative said, yep, you're right. This does violate the Voting Rights Act. You need to draw a new plan that has 2 Black majority districts. Just about a year ago, the Supreme Court took the case, stayed that ruling, and said, no, Alabama can run elections under its original plan that a federal court said violated the Voting Rights Act, and then heard argument in this case last fall, and we're waiting for a decision. And we can speculate. I'm happy to talk more about what the court's going to do. It seems fair to say the court is going to overrule the lower court. It wouldn't have taken the case and stayed the ruling if it didn't. And because in the stay order, the Chief Justice mentioned that the lower court properly applied Section 2 law as it existed, there's a sense that the court is going to use this case as an opportunity to contract Section 2 of the Voting Rights Act yet further. We don't know precisely how, and there's different plans on the table. Let me stop there. I could say much more, but I've been talking too long as is. So why don't we can go back to the slides or talk about what anybody wishes to talk about.
Yeah, I don't have any messages here in the chat, any questions in the chat.
Does anyone have any questions? There's certainly a lot to think about here.
Yeah.
No questions? Well, then, Ellen, talk about some of the things that you teased.
I think Cheryl might have a question. She looked like she might have.
Cheryl, you're muted. You're muted, Cheryl.
Yeah, sorry. Well, and I don't know, I mean, I know there's been a lot of discussion here in Michigan and especially in Detroit about how redistricting affected the vote or certainly the outcome of the vote, it appears, even though people felt that it was not going to. But so how did you read what happened here in Detroit in terms of the response of voters and of voters to voters? Like the other response.
So are you asking about the redistricting commission, the citizens redistricting?
Well, not so much the commission, but what resulted in terms of the maps they drew.
Mm-hmm.
I mean, because that affected representation now at the congressional level, and possibly at the local level.
Sure.
Too, in terms of people of color being able to be represented. So,
and you know, there's some pending litigation still on those maps. One of the things that the commission did was it unpacked concentrated districts, particularly congressional districts, of where Black voters in Detroit had been super majorities. And does the Voting Rights Act allow that to happen? Does the Voting Rights Act require that to happen? And there's a strong argument that the Voting Rights Act actually requires that to happen, that lots of Black voting strength in Detroit was diluted, or at least is a claim, by being over concentrated. Many more voters who voted cohesively were put in the district there for the Congress than needed to be to elect a representative of choice. There's a dispute now. Were those districts unpacked too much in a way that diluted voting strength? Given where the statute is at this point, I mean, it's an ongoing case. We can go into the weeds about it. I don't think that case is going to win. Just to speculate as to, I don't think it would be sustained that a federal court would uphold a violation of that act there. It's complicated, the unpacking of the districts. I don't know that the record, it's hard to say. The Democratic primary in Congress was a fracture. There were lots of candidates, and I think that may have contributed to some of the sense that didn't go the way at least some people had hoped it would have gone. That gives rise to a Voting Rights Act violation is not clear. I'm not sure that I've answered your question though. So why don't you come back in and say a little more?
No, thanks. I appreciate it.
So we're getting a couple questions here. We have someone asking about a review of the US Census results and how that caused Detroit to lose representation in Congress. I don't know if you have anything. I think what they're referring to is at the point where then President Trump stopped the census count.
So Michigan has been steadily losing congressional seats so this goes actually back. We can talk about that malapportionment from the early 20th century, the failure to redraw districts in 1962. Supreme Court said, we're going to talk about this. And then in a series of cases articulated this idea that one person, one vote, that you sort of have to have for federal elections, actually close to precisely equal population, and for state and local elections, not quite as precise, but you need not massive shifts in population from district to district. And that gave rise to this obligation after every census to redraw your districts. That's combined with what was which was already a census obligation. When the census reveals population shifts, the number of seats in Congress that Michigan or every state is going to get shifts depending on what the population is. And Michigan has lost a seat in the last several rounds of redistricting each time, and did this time as well. The Census Bureau was late. There was litigation about citizenship requirements with questions that were being put out, and then the numbers came in late. And that did create, I'm not sure this is responsive to the question, but that did create a challenge for the Redistricting Commission that was drawing maps for the first time pursuant to a new standard, got the data pretty late. But I'm happy to say a little bit more, but I'm not quite sure what.
Maybe you can, is the litigation that count was sort of being reviewed with, is that settled now, or is it ongoing?
So that is settled, if you will, that the disputed questions weren't added to the census, if that's what the question is about, sort of questions about whether you are a U.S. citizen. It was a procedural problem that the court identified. It didn't, so the question is not fully resolved in that another administration in the future, following the procedures that past administration did not follow, might be able to change the Senate questions. There's reason to be deeply worried about the questions that they wanted to put into the census about it discouraging participation. And there was speculation, and I actually don't. And I think that I believe there's evidence that it participation was low in critical communities, because even though the questions weren't added, people were reluctant to fill out the census, and certain resources were not devoted to getting a full and fair count. So there's reason to think some of the numbers are difficult.
Yeah, and Lacey has asked. And maybe I'll just read this question. I work with Disability Rights Iowa, the protection and advocacy agency in our state. I am the solo and somewhat new voting rights advocate for our organization. At this time, I'm curious to ask if there are any resources or materials that can be pointed to about how the Voting Rights Act has influenced the voting rights in Iowa, materials about how to best advocate for people with disabilities here, myself included, in the likely case that voting rights will be reduced. I know this is asked with an Iowa-specific viewpoint, but any general info would be helpful as well. Thank you for your time.
So I don't have an Iowa-specific answer to that question. There are provisions protecting voters with disabilities under the Voting Rights Act in a provision that's about language minority protections as well. Voters with disabilities are entitled to a range of accommodations, and while I wouldn't say that they're winning cases in any great number, there have been some successes of voters bringing claims for instance, visually impaired voters getting tools at a polling place or particular devices to help with the filling out of absentee ballots and different things of that sort. There's several organizations that are working for the rights of disabled voters. I don't have their sites on hand, but I'd be happy to, Lacey can email me and I'd be happy to help her connect with them.
And Lacey, too, you might check out the Detroit Public Library's YouTube page. We have an old event on disability voting rights, actually, and there's a lot of nationwide information there.
Yes, several of the groups that took part or that were mentioned were nationwide.
Yeah.
If you want to I'll see what information I have. If you want to get in touch with me directly, I'll put my email address in here.
I have another follow-up question while Jennifer is doing that. So given the state of this sort of seemingly eroding Voting Rights Act, what are the recourses if the court continues to undercut that act? Does new legislation have to be written? How does that go next? I guess.
Right. That's a great question. And I mean, there are different pieces there. So part of the problem with the Voting Rights Act is a problem with civil rights legislation more generally, and that we've seen across the board in sort of an eroding of Title VII about employment discrimination, Title VI, Fair Housing Act, really sort of the traditional statutes that comprised the anti-discrimination regime. And particularly with regard to race, the federal courts are not particularly receptive to expansive readings of these statutes at this moment in time. From my vantage point, I'll speak my personal opinion, which is not a radical opinion. That's a bad thing. And I look at the practices that are put in place, in lots of parts of this country, but here too. These protections are not obsolete. They are dealing with real and ongoing problems, and it is to all our detriment that they're not being enforced vigorously anymore. What do you do about that? So Congress could do some things about it. It's not likely to. And one of the things it could do is to sort of pass a series of statutes that are not, it's sometimes described as universalist, like not to get at racial discrimination. Frankly, I think, but protect the right to vote. Whether it's about, early voting, absentee voting on demand, easier registration procedures, easier, limitations on voter ID, rules on counting ballots that are after they're received in elections, which was something obviously in 2020 that created a lot of difficulty. I'll say that great, I would love to see a lot of those measures enacted. I think we do ourselves a disservice in not focusing or recognizing the way in which racial discrimination continues to infect all of these processes, and to sort of pretend is the wrong word, because all of these measures would do good things for lots of people, to my mind at least. But I think it's a mistake to sort of think that we're done, or that racial discrimination is something that shouldn't be targeted by our voting laws. There's stuff at the state level. State laws can be passed just in the same way state laws can restrict the right to vote. They can make voting easier, more fair. And I think we've done a great job in Michigan. 2018, 2022, we've amended our constitution. We've provided absentee voting on demand and expansion of early voting, and the whole list, in addition to creating the commission, which was a separate measure, that have made it easier and better to better procedures for voting. And I'd like to see that continue in many places. I guess, you know, the other big thing we can do is vote and make sure everybody we know votes, and help people who aren't voting, aren't registered, to be registered, and to work on all of those, you know, and in a very local way. Actually, the work that the League of Women Voters has been doing for decades now is critical, because that's how you get the votes to change the laws, to do the things that we, you know, that many of us think need to be done. There's another whole aspect to this, which is the lack of confidence that people have in the security of the electoral process and the outcomes that are determined. And I will confess I have no answer to how we convince people who believe things are stolen. We had a commission here on the Senate, the Michigan Senate put out a bipartisan report parsing all the 2020 allegations. And this might be too partisan. I don't mean it. This is a Senate report saying that allegations of fraud are not substantiated, and going through, I think, meticulously each of those allegations. And I'm not sure any minds were changed as a result of that. And I don't know what we can do about that, because ultimately we do need to have confidence in the system, that the system is fair and not stolen.
Thank you. Unless there's any other last questions, I think that's the end.
I'm going to put in the link to the library's YouTube channel, the special channel for the League of Women Voters programs. It will take a couple of weeks before this is loaded up, but the old ones are there. I don't remember exactly when the disability rights program was, but it was sometime, I think, last spring. If you can't find it, get in touch with me. I gave you my email address, jdye@detroitpubliclibrary.org. And we're always looking for suggestions. We're very fortunate that we had a referral to Ellen, who was happy to talk to us. We appreciate that. Next month, we will be back to our usual second Tuesday. Dr. Evan Kamenker, I hope that's correctly pronounced. He's also of the University of Michigan Law School. He's going to talk about Moore v. Harper, which is currently being considered in the Supreme Court. This has implications for how much authority state courts have to overrule state legislatures on voting questions. And it was a league member who proposed this and suggested Dr. Kamenker, and we think it will be a very interesting program. Here is the Eventbrite link for that. And we try to almost every month. The few months we plan not to, but we are looking for topics. We want to help educate people, and we want to make it entertaining. I believe Ellen made it entertaining. Cheryl, you have a question?
Not a question, but I just wanted to say I put in the chat, if anyone wants to contact the league, I have our contact information, a complete list of ways you can get a hold of us.
Yes, thank you.
And we appreciate it. And I'm sure we'd all have many questions if we had a moment to kind of think through this, but I know we don't necessarily.
Well, I think you gave us a good overview, both of the history leading up to the act and things that are happening in the last few years. Shirley, I can unmute you if you would like. You can put something in the chat saying yes, or you can put your question in the chat. All right, I'm going to unmute Shirley.
Hello.
Hi.
Thank you for doing this. A friend that was in the hospital called in the middle of it, but I heard a lot of it. And I wanted to know if, like, can we share this video with a women's group, like I'm a member of the General Federation of Women's Club? Or can somebody come and talk on this? How would we share this presentation today?
Yes, well, in terms of Ellen talking, then you could get in touch with her. You can contact me, and I will put you in touch with her if you'd like. The recording will be up on our YouTube channel in a few weeks. It takes a while for marketing to get them up,
Right.
but you are welcome to share it then.
On the league also.
The league will also have it, the
Very
local
good.
chapter, but they get it from our copy.
Well, this was, you know, I almost feel like the women's chapters should have somebody from the League of Women, like I'm the General Federation of Women's Club. Somebody from the league should come speak once a year almost, because the way things are changing so much.
It sounds like it would be a good collaboration.
Shirley, where are you located?
I'm in Dearborn. I'm in a member of a small group, but we cover from Ypsilanti, Ann Arbor, all the way to Dearborn.
Okay.
And we are concerned citizens, and we have representation in Washington, D.C., because there are little chapters all throughout the United States, some big, some little. So we do care about what's going on in the state and the country. We really do, and locally. So I thought this was very enlightening, and we've got to spread the word.
Okay, well, thank you, Shirley.
Thank you.
It's looking like that is probably it. So thank you, Ellen. Thank you, Ruth and Cheryl, as always. Thanks to Deborah for doing an introduction to the chapter. And I hope to see you in another month. And you are certainly welcome to look at the recording, share any of our recordings, either from the DPL YouTube channel or from the League's webpage. Thank you.
Hey, Jennifer,
Yes.
I'm sorry, I have one more thing, and that is last year in February, we had a forum which focused on the aunts of one of our members, his two aunts who as teenagers crossed the bridge at Pettus, and their experience that day when all that happened. At any rate, and they talked about how they as teenagers got out of school, did this. It's really wonderful, and I think everybody might benefit from that. One of our members, Charles Thomas, organized that, and it's on the League website, but also on the library. So and they again did that again this year. They talked, I think, live streamed their discussion with high school students in Detroit, and to help them understand what it was like to be there. I found your examples, even though it's not people always, but just seeing a poll packs information, as well as hearing about all of that, just makes it a bit more real and helpful.
Yes, Charles's aunts took part in all 3 marches, and they did finally make it to Selma with the final march. Well, thank you everyone for showing up, and hope to see you in another month. Thank you again, Ellen.
Thank you.
Yes, you're great.